Okay, now we're moving on to civil liberties. First thing we need to do is distinguish between the differences with regard to civil liberties versus civil rights. Civil liberties are protections for individuals against arbitrary government action. That is to say that the idea of civil liberties is that the government can't do something to you as an individual. For example, the government cannot deprive you of some of your natural rights, life, liberty, property, specifically things such as free speech, free press, and so forth. All of those are concepts associated with civil liberties. Civil liberties protects individuals, or you could think of it as protecting everybody in the society at the individual level. This can be different. This can be contrast with civil rights. Civil rights deals with protecting groups in the society. The essence of civil rights is equality, equal treatment. Civil liberties is about protecting natural rights. Civil rights is about protecting equal or providing for equal status among various groups in the society. So if you're presented with a question, if the essence of the question isn't dealing with equality, it is probably not a civil rights question. It is probably a civil liberties question. While we typically think of the Bill of Rights as protecting civil liberties, and it does, there are some civil liberties protections in the original text of the Constitution. For example, there is protection for the writ of habeas corpus. As we mentioned earlier in the Constitution lectures, that habeas corpus is a way in which an individual gets out of unlawful incarceration. A writ of habeas corpus is an order issued by a court to a jailer or warden to explain to the court why an individual is being held. It protects an individual against unlawful incarceration. Ex post facto laws are laws that are criminal laws that are retroactive in nature. So what an ex post facto law would do is it would make something that was legal in the past illegal in the past, and consequently could subject everyone who engaged in that activity in the past to some sort of prosecution. Ex post facto laws, again, are criminal laws that are retroactive in nature. Bills of attainder. A bill of attainder is a law that declares by name a person guilty of a crime. And then the Constitution also provided for basic protection for jury trials in criminal cases, and this will be expanded later on in the Bill of Rights. Because the United States is a federation, you have to think about civil liberties in the context of both the national government and the state government. Your protection against arbitrary and capricious action against the national government is provided for by the United States Constitution and the accompanying Bill of Rights that is part of it. Your protection against arbitrary state action is provided for by your state constitution, which will provide you actually the maximum level of protection, and the United States Constitution, which will provide you the minimum level of protection. The United States Constitution, because of selective incorporation, provides minimum standards that states must comply with regard to civil liberties. Can your state provide protection for civil liberties at a greater level than does the U.S. Constitution? Absolutely it can, and it can do so through the state constitution. Selective incorporation. Selective incorporation is the process of applying parts of the Bill of Rights to the states on a case-by-case basis. The Bill of Rights originally did not apply to the states, and this was declared specifically in the case of Barron v. Baltimore, 1833. Originally, the Bill of Rights only restricted the national government. That's what its job was protect you against arbitrary action from the national government. Arbitrary action by your state government was prohibited by your state Bill of Rights. The 14th Amendment will be passed in 1868 in the aftermath of the U.S. Civil War, and it will contain a provision in it called the Due Process Clause. And this will make possible selective incorporation in the case of Gitlow versus New York. Gitlow versus New York, 1925, is when the Supreme Court of the United States used the 14th Amendment Due Process Clause to begin the process of selective incorporation. You could probably, in fact you can find some earlier cases where something like this occurred, but for purposes of this course, the landmark case is going to be Gitlow versus New York, 1925. That's when the court began the process of selective incorporation. Gitlow is a speech case, but That's not really why it's significant. It's significant because that's when the court began selective incorporation. It should also be emphasized that the incorporation is selective, not total. That is to say that there are parts of the Bill of Rights that today do not apply to the states. The Third Amendment has not been incorporated. The Fifth Amendment grand jury indictment rules have not been incorporated. The Seventh Amendment has not been incorporated. The Eighth Amendment rules regarding bail, there is some debate, some question as to whether those have been incorporated or not. So, as you can see, while incorporation is not total, most of the important parts of the Bill of Rights have been applied to the states. 14th Amendment. Let's break down Section 1. Section 1 of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This is known as the Citizenship Clause. It is the first clause of Section 1 in the 14th Amendment. This has a federal impact in that it deprives states the ability to decide who is and who is not a citizen of their state, which was common practice prior to the ratification of the 14th Amendment. Next is going to be the Privileges and Immunities Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This clause has practically no meaning today. It's gutted by a series of cases known as the slaughterhouse cases. And for purposes of this course, it is not important. 14th Amendment Due Process Clause. No state shall deprive any person of life, liberty, or property without due process of law. This clause restricts state action, and because of the concept of selective incorporation, states, because of this clause, will not be able to deprive you of most of the protections of the U.S. Bill of Rights. This clause does not apply to the national government. The verbiage of the clause is no state can deprive any person of life, liberty, or property. So again, it doesn't apply to the national government. It does, however, apply to local governments because local governments are part and parcel of states. The 14th Amendment Equal Protection Clause. The 14th Amendment Equal Protection Clause prohibits states from denying to any person within their jurisdiction the equal protection of the laws. This is going to be the basis for the national government regulating the states in the area of civil rights. First Amendment. The First Amendment protects religious liberty or religious freedom in the United States. The First Amendment contains two specific clauses that deal with religious liberty, and each one has a specific function. The first one is what is known as the Establishment Clause. Congress shall make no law respecting an establishment of religion. The function of the Establishment Clause is to prohibit the national government from preferring one religion over another. The essence of the Establishment Clause is to require that the national government maintain neutrality in the area of religion. It can neither promote nor denigrate a particular religion, nor can it promote or denigrate religion in general. The next clause is known as the Free Exercise Clause. And what this clause does is it, for the most part, prohibits the national government, and because of selective incorporation states, from interfering in the practice of your religious faith. Okay, cases of note. The first one is going to be Engel versus Vitale. This is the so-called prayer in school case. The Board of Regents for the state of New York, which is similar to, which is in effect their state school board, had prescribed a prayer that students would teachers would be required to lead students in every day. And the prayer tried to be non-sectarian, that is to say, it tried not to mention or promote one religion over another, but to be some sort of plain Jane, generic prayer appeal to some sort of deity. Anyway, the Supreme Court held that this was a violation of the Establishment Clause because it was having public school employees, teachers, lead students in the performance of a religious exercise, which has the effect of promoting religion. So this is going to, so teacher-led prayer in public schools is going to be declared unconstitutional with the case of Engel versus Vitale. Similar logic is going to be used in a case called Abington School District versus Shemp. In the case of Abington versus Shemp, the state of Pennsylvania had required the reading of a certain number of verses from the Bible at the beginning of each school day. So in this case, the Supreme Court asked the question, well, what would be the purpose of this particular activity, this particular requirement? And it held that the purpose of the requirement was, in fact, to promote some sort of religion. While the Bible can be read in public school if it serves a secular purpose. For example, study of religion, study of history, study of biblical references and literature. That's perfectly acceptable to refer to the Bible and to quote it. However, to place it at the beginning of the day as part of opening exercises or give it some sort of ceremonial place, that would serve to promote a religion, and that would be in violation of the U.S. Constitution's Establishment Clause. Lemon versus Kurtzman. In this case, the court deals with government aid to religious organizations. The Constitution of the United States, the First Amendment thereof, is often said to create a wall of separation between religion and the state. However, that wall has never been the wall has never created a total separation between religion and government. While some people should argue there should be more separation, other people might require there should be less separation. The separation is not complete. So can a government agency, both either national or state, give money to a religious entity? And the answer is yes. In the case of Lemon versus Kurtzman, the Supreme Court gives us what is known as the Lemon test to help define when that aid is appropriate. Lemon test has three parts to it. Number one, the aid has to have a secular purpose. So tax dollars from a government agency can be given to a religious organization if the aid has a secular purpose. Number two is going to be the aid has to have a neutral effect, either enhancing or denigrating the religion. And then finally, the aid has to avoid excessive entanglement. Case of Wisconsin versus Yoder. In this case, the Supreme Court ruled that a compulsory attendance law in the state of Wisconsin violates the religious rights of some Amish individuals. What was going on is that students were required to attend public school up through high school, and the Amish in this instance argued that doing so works an undue hardship on their religious faith, because part of their religious faith is to have a simple life, and they argued that requiring people to go to high school in effect undercuts their religion. The court also ruled that while Wisconsin does have a legitimate government interest in ensuring that people can read and write and do basic math, that need had been met by the time the students were in 8th grade. The First Amendment of the United States also provides for free expression. Free expression is provided for in the verbiage that requires that the Congress cannot abridge the freedom of speech or of the press or the right to peaceably assemble. So these things are designed to protect an individual's right to express his or her opinion regarding public policy.